Tonight, I want to share news of a development that arrived quietly in the final hours of the workday, one that was largely overshadowed by louder headlines about border policy and economic indicators. Still, it should not be dismissed. What took place inside a secured federal courthouse in Washington, D.C. this afternoon marks the clearest sign yet that the machinery of justice, which has moved with deliberate caution for the past 18 months, is finally approaching a decisive moment. Legal experts and former prosecutors described today's grand jury session as procedurally routine but symbolically explosive, a culmination of evidence that could expose Donald Trump to criminal liability unprecedented in American history. At a glance, this could be mistaken for another day of testimony, another round of behind-the-scenes legal maneuvering. But this was never about process. It's about accountability. What follows will uncover the parts of this episode most people haven't seen, why federal prosecutors became so intent on presenting their complete case now, why the grand jury responded with such apparent unanimity, and why the Department of Justice, an institution that has frequently proceeded with extreme caution regarding executive power, finally decided this was the moment that could not be delayed any further. At a glance, this could be mistaken for routine grand jury proceedings, another predictable step in a months-long investigation that has generated countless headlines but little concrete action. But this was never about adding another layer of testimony to an already massive evidentiary record. It's about crossing the threshold from investigation to formal accusation. What follows will uncover the parts most people haven't seen. Why Department of Justice officials accelerated their timeline after initially signaling they would extend deliberations into late February. Why the grand jury's final session lasted nearly 7 hours rather than the anticipated 3. And why court insiders, people who have observed hundreds of federal cases, describe the atmosphere inside that deliberation room as unlike anything they have witnessed in careers spanning decades. To understand how we arrived at this moment, the sequence of events matters. Roughly 6 weeks ago, Special Counsel Jack Smith's team began what legal observers characterize as the final phase of evidence presentation. Documents obtained through subpoena, financial records spanning Trump's business empire, communications between senior advisors, and testimony from more than 40 witnesses were methodically introduced. The objective was never simply to establish that certain actions occurred. What followed went far beyond demonstrating factual timelines. The objective was to prove criminal intent, to show that Trump knowingly, willfully, and with full awareness of legal prohibitions, engaged in conduct designed to obstruct constitutional processes and defraud the United States government. At this point, the behavior moved beyond ethical violations or political misconduct and into potential federal criminal territory. That shift is precisely what prosecutors identified, culminating in today's decisive grand jury session. At exactly 1:47 p.m. Eastern, the final panel of witnesses concluded their testimony before the 23 grand jurors seated in courtroom 23A. It was framed publicly as the completion of evidentiary hearings, a procedural milestone that federal prosecutors had anticipated for weeks. Buried in its significance, however, was a reality that legal experts immediately recognized. Prosecutors do not conclude evidence presentation unless they believe they have established every element of their case beyond reasonable doubt. What followed went far beyond standard grand jury procedure. The objective was to secure an indictment that would withstand not only immediate legal challenge, but also intense public scrutiny and historical examination. The presentation proposed charging Trump under multiple federal statutes, including obstruction of justice, conspiracy to defraud the United States, and potential violations of the Espionage Act related to classified document handling. According to sources familiar with the proceedings, prosecutors walked grand jurors through a timeline spanning November 2020 through August 2022, demonstrating what they characterize as a coordinated scheme to subvert legitimate electoral processes. There were even proposals, according to legal observers who have reviewed portions of the sealed evidence, to charge Trump with witness tampering based on communications with former White House counsel Pat Cipollone and Deputy Counsel Patrick Philbin. Put plainly, this amounted to a comprehensive criminal case touching every major controversy of Trump's final year in office and beyond. At this point, the presentation moved beyond political accountability and into potential criminal conviction territory, carrying sentences that legal experts estimate could total between 15 and 30 years if Trump were convicted on all counts. That possibility is precisely what the grand jury considered during their deliberations, which extended from 2:15 p.m. until approximately 9 p.m., far longer than the typical 3 to 4 hour timeline for final deliberations. After reviewing approximately 100 to 200 pages of documentary evidence, listening to audio recordings of conversations between Trump and senior advisors, and examining financial records showing the movement of roughly $18 million through entities controlled by Trump associates, a clear pattern emerged. What prosecutors characterize as systematic obstruction designed to prevent the peaceful transfer of presidential power. The so-called big lie narrative about election fraud was never meant to be supported by genuine evidence or investigated through legitimate legal channels. Instead, according to the prosecution's theory, it functioned as cover for a broader scheme involving the coordination of fake electors in 7 states, pressure campaigns targeting state election officials, and ultimately the events of January 6th itself. The plan involved routing directives through intermediaries, including former White House Chief of Staff Mark Meadows, Attorney John Eastman, and political advisor Steve Bannon, creating what prosecutors describe as plausible deniability while maintaining Trump's central role in decision-making. This evidentiary architecture explains today's extended deliberations and the apparent consensus among grand jurors that an indictment is warranted. The grand jury determined, according to court insiders familiar with their discussions, that Trump's conduct violated multiple federal statutes and, more fundamentally, breached the constitutional oath of office, requiring presidents to faithfully execute the laws. It undermined the foundational principle that no person, regardless of position or power, stands above legal accountability. The Department of Justice's approach to this case has been methodical, deliberate, and, according to legal analysts, strategically designed to withstand the inevitable challenges Trump's legal team will mount. The presentation emphasized that preliminary discussions about challenging election results occurred not in isolation, but as part of a coordinated effort that continued even after dozens of court cases were dismissed and after the January 6th attack on the Capitol. In other words, Trump allegedly persisted in conduct he knew to be legally prohibited, even after being explicitly warned by White House counsel, campaign attorneys, and the acting attorney general that his actions violated federal law. The $18 million in funding that moved through political action committees and nonprofit entities during this period, prosecutors argue, demonstrates the systematic nature of the scheme rather than spontaneous political activity. Which brings us to the timing itself. For much of the past year, the Department of Justice has proceeded with extreme caution, repeatedly extending deadlines and allowing Trump's legal team additional time to respond to subpoenas and negotiate over executive privilege claims. So, what shifted? Why did prosecutors at this particular moment choose to accelerate their timeline and push for a grand jury decision within the next 72 hours? It had nothing to do with political pressure or electoral considerations. The real reason is prosecutorial strategy combined with an approaching deadline created by Trump's formal announcement that he will seek the presidency again in 2024. In Washington, the unwritten rule is that the Department of Justice avoids actions that could be perceived as interfering with elections, typically implementing a 60-day pause before any major election. When Trump declared his candidacy in November, it sent an unmistakable message to prosecutors. The window for action is closing. Any indictment must come soon or face delays extending well into 2024. This timing marks one of the clearest signs yet that Trump's legal jeopardy has reached a critical threshold. It's among the first real indications that federal prosecutors believe they have assembled a case capable of securing conviction. Still, it would be reckless to underestimate the legal and political battles ahead. A $75 million penalty in the New York civil fraud case represents one form of accountability. A federal criminal indictment carries consequences of an entirely different magnitude. The implications extend far beyond Trump himself. The precedent being established here will shape executive accountability for generations. No former president has ever faced federal criminal charges for actions taken while in office. The constitutional questions are profound. Can a president be prosecuted for official acts? What constitutes the boundary between political activity and criminal conduct? Does the pardon power extend to self-pardons? Legal scholars describe these questions as among the most significant constitutional issues since Watergate, challenges that will likely require Supreme Court intervention to resolve definitively. The cultural consequences are equally significant. Trump has spent years attacking the legitimacy of federal law enforcement, characterizing the FBI as politically weaponized and the Justice Department as corrupt. Controlling the narrative around his legal troubles is a direct route to controlling how his supporters interpret accountability itself. His goal has been to overwrite the legacy of equal justice under law, a principle built on transparency, evidence, and constitutional limits on executive power, with a narrative rooted in persecution, political vendetta, and deep state conspiracy. The grand jury may have voted to indict, but it cannot end the larger struggle for how Americans understand the relationship between power and accountability. That battle is playing out in courtrooms across the country, where Trump faces charges in New York, Georgia, and now potentially federal court in Washington. It's happening in Congress, where Republican lawmakers must decide whether to defend Trump or distance themselves as criminal proceedings intensify. The grand jury's decision represents merely the most visible tip of the iceberg. Behind it lies a systematic effort by Trump and his allies to reshape American governance itself, to establish that presidents operate beyond legal constraint, that loyalty matters more than law, and that accountability applies only to political opponents. This is not about one investigation or one indictment. This is about whether the constitutional principle that no one is above the law retains any practical meaning in American democracy. And let this serve as a clear message to those in power. We are watching the legal proceedings. We are watching how elected officials respond. We are watching whether institutions designed to protect democracy will fulfill their purpose. We will not allow constitutional principles to be eroded piece by piece through claims of executive immunity and political grievance. Still, it would be reckless to underestimate the danger ahead. A former president who feels cornered, facing criminal charges, carrying potential prison time, and watching his financial empire simultaneously collapse under the weight of civil penalties is not a diminished threat. Trump has never accepted defeat quietly. He doesn't interpret legal accountability as a legitimate check on power. He interprets it as persecution, as treachery, as justification for even more extreme responses. The next 72 hours matter. With an indictment decision imminent and additional investigations in Georgia and Florida reaching similar critical phases, Trump's legal vulnerability has reached unprecedented levels. Pressure shapes behavior. And when conventional legal defenses fail and political allies begin calculating their own exposure, attention inevitably shifts toward more desperate measures. Which brings us back to the warning about Trump's public statements. Watch for increasingly inflammatory rhetoric designed to mobilize supporters and create the impression that any conviction would be illegitimate. Expect attacks on individual jurors, witnesses, and prosecutors that could constitute witness intimidation. Anticipate claims that he will refuse to comply with any conviction, potentially setting up a constitutional crisis unlike anything in modern American history. Desperation doesn't retreat, it adapts. We may also witness emergency legal motions claiming immunity, attempts to move trials to more favorable jurisdictions, or efforts to delay proceedings indefinitely through procedural challenges. Today's expected indictment represents a clear win for the rule of law, but it also raises the stakes enormously. It increases the temptation for Trump to pursue strategies that further undermine democratic norms and constitutional processes. To the citizens who have felt powerless watching these events unfold over the past 3 years, I want to speak directly. I know how easy it is to feel like the institutions designed to protect us have failed. I know the disillusionment of seeing accountability delayed while Trump continued campaigning, fundraising, and attacking the legitimacy of the judicial system itself. But look at what has occurred. Look at the scoreboard. A grand jury of ordinary citizens presented with evidence and asked to apply the law without regard to political consequence appears to have concluded that Trump should face criminal charges. Federal prosecutors, career officials who understand the gravity and risk of indicting a former president have staked their professional reputations on this case. If one of America's most powerful individuals can be held accountable through legitimate legal processes, so too can democracy itself be preserved. We cannot safeguard constitutional principles selectively, defending them when convenient, while ignoring violations that occur behind closed doors or through procedural manipulation. Those prosecutors who presented this case with such care must show the same commitment across all investigations. And let this serve as a clear message to those in power. We are watching the evidence. We are watching the legal proceedings. We are watching whether equal justice under law remains more than an empty phrase. Democracy is not a spectator sport. It requires active participation, constant vigilance, and courage from every one of us. If this breakdown helped cut through the noise and explain what's truly at stake in the coming days, consider subscribing. The next 72 hours will be pivotal, and I'll be tracking every development, every filing, every response as this historic case unfolds. I'd like to hear how you see it. Do you believe this indictment represents justice finally being served, or does it set a dangerous precedent for prosecuting political opponents? Let me know your thoughts in the comments below. Thank you for watching. This story is far from over.